Let's catch up with Seth Olale, who is at the Milimani Law Courts. Seth, just looking at some of the highlights that came out of the Court of Appeal today, I saw that they issued several directions. Some of the directions include that they declined to order interim orders suspending proceedings before the Justice Ogula-led bench until Wednesday, that the Court of Appeal will sit on November the 6th for oral arguments in Gachagua's case, orders service by Friday, responses by Monday. So can you give us a bit more detail on why the Court of Appeal declined to issue conservatory orders?
Well, good afternoon, Olive. Basically, I cannot speak on their behalf, but I think that particular bench, like you said, the Justice Kiage Patrick-led bench in the Court of Appeal did respond to that particular request by Senior Counsel Paul Mwite when he requested the court to issue stay orders in regards to having interim instructions, rather preventing the lower court, which is the High Court, from proceeding with this impeachment process along the corridors of justice. And the presiding judge there, Justice Kiage Patrick, did acknowledge that he is aware of the proceedings going on in the lower court, and he is also aware that there is a number of petitions that have been consolidated, and that this being matter of public interest has also been certified as urgent. And it is for this very reason that this particular higher court, the appellate court, did have that session in the morning. But as to the exact reasons in detail where they denied Senior Counsel Paul Mwite that particular request of having at least interim orders staying proceedings at the High Court, they did not respond to that in detail, and that's why I'm telling you, Olive, maybe I cannot speak on the court's behalf.
All right, Seth, what do we expect the High Court to rule on this afternoon?
Well, I think the three-judge bench led by Justice Eric Ogola, that also include Justice Anthony Mrima and Freda Mugambi, has by this time looked at the arguments that were submitted before them during that particular hearing. Remember that there were key issues in regards to which will favor a ruling of that nature, issues to do with the jurisdiction of the High Court itself in determining whether it can even issue a ruling in regards to an impeachment process being undertaken by a legislative arm of government, that is the National Assembly and the Senate. Also, there were questions in regards to how the impeachment process was conducted right from the National Assembly and to the Senate. Talk about the public participation exercise that came in very clearly, that those that argued, especially the applicants, the petitioners in this particular case, lawyers representing impeached Deputy President Rigathi Gachagua, indicating that the public participation process was a complete sham. They also mentioned where they thought that there were anomalies such as areas such as KU South, where they said they did indicate that the turnout, the participant turnout in that particular area was more than 140%. But the respondents in this particular case, of course, being led by the Attorney General, the Senate, the National Assembly, and the speakers of both the Senate and the National Assembly, including interested parties such as Professor Kithure Kindiki, who's been enjoined in this particular matter, arguing that a public participation exercise is not an equivalent to a voter turnout exercise, and it does not have to involve half of the country's population, 25 million Kenyans. It's supposed just to represent a section of views taken at least from all the constituencies. So, like I said, there are issues in regards to the jurisdiction of this particular court in handling or determining if it can execute matters regarding impeachment of a deputy president or a president. There are also issues in regards to the manner in which this particular process was conducted, and also there is an issue about the public interest. Where does it favor? Remember that the court did indicate that this already is a matter that has attracted a huge public interest, and it will also pronounce itself as it where does the public interest tilt most? Is there an urgent need to address issues regarding both impeachment and replacement of a deputy president, or could this particular process wait? Remember also the petitioners had argued that according to the law, there is a stipulated time of 74 days to replace a sitting another deputy president. So where is the urgency? And in this particular moment, whether the court issues conservatory orders, extends these particular orders, or vacates them, in whose interest will it be? It has to be for the public interest. So these are just some of the arguments that the three-judge bench led by Justice Eric Ogola is supposed to come and address. What we know is that they will perhaps give a summarized ruling or determination of this particular matter, and later on back it up with a very detailed decision. Olive.
For bringing us up to speed, Seth Olale, with what transpired at the Court of Appeal virtually, and what we can expect to hear from the three-judge